Good afternoon. The Senate Judiciary and Public Safety Committee will come to order. Today is Wednesday, April 3rd, 2024, and we do have a quorum present. We're going to take up Senate File 4053 first. Senator Dibble, Minnesota Cooperative Housing Act. Members, you do have your packet materials. This comes to us from the Housing and Homelessness Prevention Committee. There is an amendment that's in the packet, but obviously not an author's amendment at this point. So, Senator Dibble, why don't you tell us a bit about your bill? Give us the 30,000-foot view, if you would. I think all of this is within our jurisdiction because it's a housing-related bill. So, members, your staff summary is available for you to take a look at as well. Senator Dibble.
Thank you, Mr. Chair and members. I will try to give you a very brief high-level overview of this 101-page bill in front of you. Just very quickly, Mr. Chair and members, very pleased and honored to be able to present Senate File 4053. I'd also like to thank my co-authors, Senators Port, Westrom, Pappas, and Draheim. Senate 4053 would create a new section in state law, Section 308C, which would be called the Minnesota Cooperative Housing Act. Currently, housing cooperatives in our state we have housing co-ops, but they're organized and they're formed under existing agricultural and utility co-op statutes, which would be 308A and 308B. And nonprofit statutes under 317A. So in each of those statutes, housing co-ops have been pretty much, square pegs in round holes. And we haven't really had in statute a contemplation of a structure specifically geared towards housing co-ops. And there are a number of different types of housing co-ops, which we can get into in a little bit if you so desire. But they are becoming an increasingly popular part of the housing continuum, particularly if we're trying to target affordable home ownership and giving people that opportunity to become housing members in an entity and live in common with other folks of similar interests. In particular, Mr. Chair, just by way of context and background and why I'm carrying Senate File 4053. Last year, working with a number of advocates and proponents, proposed to the Housing Committee an attempt to assist people in buying into what we call limited equity co-ops, which really lowers the barrier of home ownership and allows people to buy into a membership type co-op housing situation, whereupon we discovered those don't actually exist in Minnesota. We have a lot of senior co-ops and things like that, but we don't have an entity known as a limited equity co-op, and this would remedy that. So the goal of this legislation is threefold: to clarify and streamline the process for housing co-ops to incorporate and function in Minnesota, hopefully creating more of them; preserve our existing co-op and housing statutes so they continue to work for the types of co-ops and housing types they were initially created for, and kind of getting them out of the ag and utilities and common interest ownership community statutes where they don't really fit in very well. And then streamline access to funding for housing co-ops, like I mentioned before, defining housing co-ops in statute. Private, public, and nonprofit funders can now have a set of criteria by which to evaluate their investments and set their standards. A couple of notes: this does not repeal any existing statutes. It incorporates pieces of existing law from throughout statute into a consolidated section. That's why it's so long. It has a lot of details and a lot of elements. Does not reincorporate housing co-ops who have already incorporated under existing co-op statutes. If they want to do so, they have to proactively elect to do so. They may choose to stay incorporated under their existing statutes, or they may choose to change and come in under 308C, which they would do by super majority threshold of their members. And there's no fiscal impact. With that, Mr. Chair, I can throw it to Joel Hansen, who can do a high-level overview of the elements of the bill, if you'd like, and then we can go to the amendment.
Yes, let's do that. Mr. Hansen.
Appreciate it, Chair Latz, members of the committee. Thank you. My name is Joel Hansen. I'm the Communications and Advocacy Manager at North Country Cooperative Foundation. This bill came out of a consortium of folks within the cooperative housing sector as well as just the cooperative sector in general. And so we started our work. Well, I should back up. It's been a long time coming. As Mr. Nemo, who is an attorney in the cooperative law sector, can testify to later, it's a 30-year process to try to get 308C to today. Obviously, I have not been involved for 30 years, but we started this process last summer and began meeting with the Cooperative Network, North Country Cooperative Foundation, Riverton Community Housing, who is leasehold cooperatives here in the state of Minnesota, the Senior Housing Cooperative Council, that represents all of the senior housing cooperatives in Minnesota, as well as Homes for All Coalition. And so this consortium came together and formed this bill that should identify housing cooperatives as a corporate form or an entity in state statute. As Senator Dibble has already said, they do not exist currently as their own entities. And so with that, we can stand for questions.
Or, Mr. Chair, I can go to the amendment.
Let's do the amendment. Members, we have the A14 amendment has been distributed. Senator Dibble.
Thank you. What this amendment is the product of is a conversation, a compromise between the cooperative housing stakeholders and the State Bar Association's common interest ownership section of the bar, the folks who take a particular interest in Section 515B of state law. And it clarifies that this new chapter would be established, but the consumer protections that are present in 515B, which is known as the Minnesota Common Interest Ownership Act, the MCIOA, is current state law and would be subjected to those consumer protection provisions that are in 515B. And in any case where there might be a conflict between what we find in new 308C, 515B would prevail, would govern. It also, the amendment also provides an extended effective date. So we put the effective date out until next year so that there can be more opportunity to discuss some more of those issues around consumer protection, et cetera, that you would find in 515B and could further work on in that discussion between folks who have that focus and folks who are working on establishing housing co-ops. And, Ms. Primo helped write the amendment, so she can help if I need any help in further clarification. Mr. Hansen was also involved in negotiating and discussing this compromise.
So, Senator Dibble, I understand then that the stakeholders that have an interest in this bill are in agreement that this amendment would move the ball forward, and then the effective date would be after next spring, the 2025 legislative session, so there'd be further opportunity to update 515B.
Correct, yeah. So if you look at 2.8, the article would be effective August 1st of 2025, giving us more than a year for more conversations about what elements of the Common Interest Ownership Act should apply to 308C. Plus, I think there are some issues within the Common Interest Ownership Act that's outside of 308C that people have an independent effort going on to address. That conversation would occur in conjunction with 308C, but it's a little bit outside of this conversation. It's another kind of separate project, but it would have implications for 308C, and so that there needs to be time for that to occur as well, and to bring a proposal to the next legislative session.
And so those stakeholders include the Minnesota State Bar Association, anyone else that we should be aware of that were participating in this?
No, I don't think so. Yeah, the State Bar Association has indicated they're comfortable if this amendment goes on, they're comfortable with 4053 moving forward.
All right. Is there anyone in the room that wants to testify in connection with the proposed amendment? Not seeing anyone come forward. Senator Pappas, would you be willing to offer the amendment?
I be happy to offer.
I'd move the amendment.
Senator Pappas moves adoption of the A14 amendment. I should ask if there are any questions from members of the committee before we take a vote on that. Senator Kroon?
Thank you, Mr. Chair. Can you give me some examples of consumer protections that are present in 515B that are not present in this bill?
So, Mr. Chair, there are things
Senator
like consumer, buyer notifications, and other forms of rights that we're familiar with in a lot of real estate transactions. But Mr. Nemo here has a intimate acquaintanceship with 515B, so he can describe some of those protections that we'd be bringing into this model of cooperative ownership.
Mr. Nemo, go ahead and state your name and affiliation and your interest in the bill and answer the question if you can.
Thank you, Chair Latz. Joe Nemo. I'm an attorney at the Arthur Chapman Law Firm and practice cooperative housing law, both in the state and outside of Minnesota. Senator Kroon, the consumer protections, 515B enumerates a number of consumer protections. Some are on the buyer side. When you come in, everyone, if you're a prospective buyer of a membership interest, you need to be furnished with an information bulletin and disclosure statement. If you're one of the fledgling members as a cooperative is being built, for membership resales thereafter, a resale disclosure certificate is used, and then all of the org docs of the cooperative corporation need to be provided. And then there's a 10-day rescission period for that person where they can back out without penalty. 308C does incorporate a lot of those protections within the senior housing component of the Act. So those are, I believe, some of the consumer protections that they're talking about with respect to 515B.
Senator Kroon.
Thank you, Mr. Chair.
I could also
Mr.
elaborate. So one other provision, like for consumer protections, is turnover of a developer board to a member board. And so 515B currently stages that based on occupancy. So after a cooperative is built, once it gets up to 75% occupancy, the developer is required to turn governance of the cooperative board over to the members. And so it becomes member-run. 515B contemplates that there's a singular way that cooperatives get formed and turned over, namely a developer buys land, holds fee title to it, builds the project, turns it over to the cooperative after it records a declaration of common interest community. And then the developer can reserve any rights it wants to reserve to the place, but turns the membership over. Most of the cooperatives, actual housing cooperatives in the state, are set up on a different model because a lot of them are under federal programs that require that the cooperative corporation build itself, be in fee title, and have individuals with the developer run the board while it's being built and then turn it over. Some of those federal programs have guidelines about when that turnover occurs, and it's usually after certification for occupancy. So I do think that some of the consumer protection concerns that have been raised with respect to 515B and a lack of those same protections in 308C, it's not that the consumer protection isn't there in 308C, it's just there differently. It's structured differently in 308C, for example, and triggers more with certification of occupancy. And that's because really most of the senior housing cooperatives in the state have mortgages insured by HUD, and HUD requires a certain methodology for turnover of the board because they structure each project with 2 closings. And member board can't be turned over until that final closing occurs, and the accounting is done to make sure that all of the project costs are paid and the accounting books are square.
Senator Kroon.
Thank you, Mr. Chair. So I'm just trying to get at what the amendment does. So it looks like it might incorporate some of the consumer protections in 515B to at least some of, is it just the senior cooperative, or is it to all of the cooperatives?
No, it's all of them.
Mr. Nemo.
It's all of them.
Mr. Chair.
Senator Cronin.
Thank you, Mr. Chair. And is this just certain consumer protections that were identified by the Bar Association? Or is it a wholesale incorporation of the consumer protections in 515B? I see that there's a conflict provision that 515B prevails, but is it just kind of picking and choosing certain ones that make sense, or is it kind of a wholesale adoption of the consumer protection provisions in 515B?
Mr. Nemo.
Thank you, Chair Latz. Senator Kroon, the amendment incorporates all of the provisions of 515B. It becomes subject to 515B. So everything, all of the consumer protections within that act, it actually, the way it's structured is 308C wouldn't be any different than, say, 308A. Right now, without 308C, when I create a cooperative corporation, I incorporate it under 308A. And 308A is subject to all the consumer protections of 515B because it becomes a common interest community under the Act. Where there's a conflict, 308A provides that 515B controls, and 308C's amendment provides the same thing. So it functions just like 308A does currently.
Senator Cronin.
Thank you, Mr. Chair. On the effective date change, what I heard was that the intent to move it out a year was to give the stakeholders some time to iron out some additional work that needs to be done before the bill becomes effective. Is that right?
Mr. Nemo.
Mr. Chair. Mr. Chair, that's correct.
Senator Dibble.
Mr. Chair, yes. Senator
Mr. Chair.
Kroon, yes.
Senator Cronin.
Thank you, Mr. Chair. This maybe, I don't know who this is a question to, maybe the other members of the committee. It just seems like if it's not going to be effective until after next legislative session, then what is the urgency? Why do we need to pass it now if there's an acknowledgement that there's additional work is needed? None of the provisions are going to come into effect until after the next legislative session. Why don't the parties just get together and make the bill, iron out the differences and the details, and then we pass it next year?
Senator Dibble.
Thank you, Mr. Chair. It's a great question, and my response is that because a lot of work is going to be occurring between now and next year in really standing up a lot of initiatives, start communicating with the public at large and with folks who might be interested in forming co-ops and the like. And also just to be really transparent, we've got, this in hand, we've got the momentum, and this has been, this is the culmination of a 30-year effort to get us to this point. And so it makes sense that, we've got something that's ripe, that's ready to go. There are some issues that the Bar Association asked for to continue to be worked on. And they asked for this delayed effective date in exchange for being comfortable with this legislation moving forward today. But Mr. Hansen can describe to you in a little more detail what's going to be happening between now and August 1st, even though nothing is going to be incorporated under 308C between now and then. A lot of infrastructure and a lot of communication, a lot of interaction is going to be taking place between now and then.
Mr. Hansen.
Mr. Chair, Senator Kroon, so if 308C would be passed into law, immediately NCF and others in the stakeholder community would start seminars and start instructing folks how they can incorporate as a 308C housing entity. In addition to that, we anticipate lenders looking at the statute and seeing now a defined entity in state law that is a housing cooperative, which could allow for, especially on the limited equity side, more lenders to enter the game. And again, as I think Senator Dibble had already mentioned earlier, the Bar Association's MCAWA committee is going to be looking at changes to that. So as they look at those changes, I think this also gives them time to do their work as well. And so it's not necessarily just about 308C, but also, the other work that's going to be done on 515B and how that might interact with 308C.
Mr. Chair.
Senator Dibble.
I forgot to add, to really respond to the urgency of now question, which I feel, and that is, we know that we have an affordability crisis, and it's affecting people's lives. And while we're not going to solve it, between now and August 1st of next year because of the delayed effective date, to Mr. Hansen's point, cooperative housing, that form of homeownership model really lowers the barrier of entry for a lot of people, particularly under the limited equity model, but also under student housing and other forms of housing. If the structures are put in place and people can get ready, plus Minnesota Housing Finance Agency can start getting their programs ready because there's an initiative to assist with home buyer grants and the like, and they can get their infrastructure ready to make those grants available sooner rather than later. And so then once we get to this conversation that we need to have and do some of the fix-ups in this other project that's going on around 515B, then we'll be ready to go as soon as possible after August 1st of next year.
Senator Kroon.
Thank you, Madam Chair. I appreciate that answer. Some of that does make sense. It's just what I'm struggling with is usually if there's not agreement on the stakeholders and there's some consensus that some additional work needs to be done, we might pass a bill anyway because there might be portions in there that have immediacy that need to become effective, and then there's an acknowledgement that maybe there'll be some changes that have to be made in the following year. But when you push out an effective date till after the next legislative session, then I start thinking, well, if the bill's not ready, why are we passing it? Because none of it's going to be effective between now and next legislative session. So maybe we should get the bill right and get it ready before we pass it. That's kind of my only kind of thinking on it. If it's not going to be effective until after next year and it's not ready, maybe we shouldn't be putting it into law yet. But I understand the seminars and kind of the lead time in getting people familiar or getting to know about it. I guess there could be some value in that. But those are just my general thoughts on the amendment. May have some additional questions later.
So, Mr. Chair.
Senator Dibble.
So the work that's going to be occurring between now and next year is going to be specific to 515B, which is probably going to happen regardless. I think, and it's going to have implications for 308C, but I don't think it's going to reach into 308C specifically and explicitly. So this bill is ready to go. The work on 515B, as Mr. Nemo described, is going to have implications for, some of the laws that 308C is going to be subjected to. So that's why I'd very much like to pass the bill now. It's good to go. It's a done deal. There's some other work to be done over in 515B, which is going to occur anyways, and so delaying its effective date so that those provisions, are clear cut in their implications for 308C when those come about next year.
Senator Limmer.
Mr. Chair, I'll hold my questions until after the amendment.
Any further discussion on the A14 amendment? Senator Pappas moves adoption of the A14 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right. Any further discussion on the bill as amended? Senator Limmer.
Thank you, Mr. Chairman. I had a quick question. Has the Realtor lobby entered into this debate? And I don't see them in the room, but
I'm sorry, which lobby?
are they affirmative or not, the Realtor Association?
All right.
Senator Dibble.
Mr. Chair, Mr. Hansen has a response.
Mr. Hansen.
Mr. Chair, Senator Limber, yes, we have met with the Minnesota Realtors Association. They're neutral on the bill. Again, I don't ever like to speak for another organization, but they didn't view this as impacting them. It's also my understanding that they had conversations with Brian Lake at the bar as well. In regards.
Mr. Chairman.
Senator Limmer.
I was reviewing the bill summary that is in front of our committee. I noticed that as I looked down the 77 or more specific sections of the bill, that it seems to be rather prescriptive. It's a lot of provisions that say a co-op requires, or the bill describes a procedure. Is there any flexibility by a separate co-op to intentionally stray from what might become state law so that it's a bit more customized for their particular building or their ownership style? Or this seems like a one-size-fits-all in a rather prescriptive manner.
Senator Dibble.
Senator Limmer, I'll defer to the experts here on why, but yes, you're absolutely right. There are some fairly prescribed procedures and standards that are set up for the governance of co-ops. And I think that's geared towards, making sure that as folks enter into this member-owner model, it provides for as much predictability and stability as is possible. When folks are buying into a co-op, they're a member owner, and they have a right then, of course, to live, in the cooperative entities, usually a building, and that represents what we would understand as a mortgage, as an investment of their finances. And so I think the idea is, to make sure that folks really understand with, fairly prescribed and specific parameters, exactly the structure and how the entity will operate and what their rights are. People who are member owners, this is a very democratic way of owning in common interest. It's different than a co-op, for example, where you kind of elect people to represent you on a particular board, which there is a board that does act on your behalf, but many of the decisions are subject to the entirety of the membership. I think there are some opportunities there for co-ops to make decisions for themselves, what kinds of services and some of their operating parameters and the like. But I think there's a foundational reason why it's fairly specific. I don't know if Mr. Nemo has a overarching philosophical principled response to why things are structured this way.
Mr. Nemo.
Senator Limmer, I agree with what's been said. I think that is a philosophical viewpoint. I think the other thing to remember is a lot of what's in 308C is derived from 308A, 308B, or 515B. And so those acts also are somewhat prescriptive, particularly 515B, and trying to create standards that protect the community and the cooperative membership within the community and the membership shares.
Mr. Chair.
Senator Limmer.
Thank you, Mr. Chair. I'm familiar more with an HOA and the disclosures that are created for condominiums and townhomes. Similar but different due to the ownership style of a co-op. Co-ops, you're buying a share in a property, much like a stock, but it's real property. Or at least you're allowed to live in your unit, which represents that share of ownership. But unlike the rules and the documentation for an HOA, for a condominium or a townhome development, there are certain elements that have to be recorded for that entity to exist. Usually it's a nonprofit organization. There's bylaws, there's rules and regulations, not prescribed by law, but prescribed by the HOA. And so this seems to be much more prescriptive in its manner. So that was my concern. Why are we so prescriptive in a co-op and yet a similar but different property ownership allows the property owners to build their rules and regulations the way they want in their development? And so I'm just a bit confused why we have to be so prescriptive.
Mr. Nemo.
Chair Latz, Senator Limmer, could you give me an example of a section that you may be concerned about within the act?
Well, yeah,
Senator
Mr. Chair, I'll give you one. Section 49 on page 48. This is in the event that there's a sale, and it's probably an easier way to look at it is on the summary. Allows a cooperative to sell or dispose of all its assets through an affirmative vote of a majority of the board of directors, if approved by a majority of members present at a notified meeting. So I don't know how many people would be on the board of directors, but it would require an affirmative vote of the majority of just the board of directors, and then that decision would be approved by a majority of the members present at a notified meeting. I've been to some of these HOA meetings where the membership of maybe 100 units is there and maybe 20 people show up. And are you telling me that if that was similar, 6 members or 11 members of the membership could actually sell all of the assets of the co-op? That just seems to me curious why it would be so lopsided and not representing the real membership of the entire building or the cooperative.
Mr. Nemo.
Am I reading that wrong?
Chair Latz, Senator Limmer. Yes, so first of all, that section I think is heavily borrowed from 515B and the standard that it creates for common interest communities, and it brings it over into 308C so that we're creating a similar standard for housing cooperatives. The way that, and I'm just looking at the summary and not the legislation, but the way I'm reading that is it's a majority of the board of directors if it's also approved by a majority of the members who are present at the meeting. So you need a majority of the membership to do it. That's a minimum standard. Cooperatives are still free to set a more significant threshold than that, and currently under 515B, when we create a cooperative, or I create a cooperative and its bylaws for dissolution and address the dissolution as part of the bylaws, it is common for some cooperatives to say it's got to be a majority of the entire membership of record, or it's got to be a supermajority, 75%. The statute creates a minimum threshold. And I do think cooperatives have the ability to create their own structure within that. But the goal or the strategy is to try to create protections around it with a minimum standard that needs to be abided by. And cooperatives have flexibility to draft from there.
Mr. Chair.
Senator Limmer.
Could you point to the area in the bill that states that the membership can deviate from what this has in it, and that they can prescribe a more expansive role when it comes to selling or disposing of all its assets?
Senator Limmer, while they're looking at the document, I've got the bill out. Maybe we can get a copy of the bill language to them as well, if they don't already have it in front of them. But it looks like on page 48, lines 23 and 24, it does specify that an affirmative vote of the owners of a majority of the voting power must first vote to sell everything or sell a portion of it, and then the board, up on line 16 and 17, can act to implement that. That's the way I'm reading it. It doesn't answer your specific question, where does it say that the board could do more, require a supermajority instead of a majority? But maybe that helps, unless I'm reading it wrong. That's the way I read it. I would say maybe there's a more clear way to write this, rather than having to wait until the last sentence of a 8 or 9 line paragraph to find out that the majority of the members have to vote to approve it before the board can vote to approve it. But that's the way I'm reading it. Senator Limmer, does that help at all?
It does. The reason I brought this up is that recently I was reading a news article on the sale of a condominium building in Florida. As you might remember, there was a condominium building, multi-story, that collapsed. And it was due to some building code, not violations, but old building code requirements that were not holding the building up any longer. And a lot of the condominium buildings are now going through a statewide review, costing a lot of money. And developers are now being attracted to these older buildings to buy out the whole building so that they can rehabilitate the entire multi-story building. In order to do that, at least in that state, or maybe it was that condominium rules, it required 80% membership to agree to sell the building to a developer. And I was just had that in the back of my mind as I was looking at sale of property and assets. It seemed like a very low threshold compared to another state or another association somewhere that requires a much higher threshold to sell the entire asset. So that's the reason why I was raising this question.
So, Senator Dibble or Mr. Nemo, to the specific question, whether or not the cooperative can set a higher threshold than a majority of the membership.
Chair
Mr.
Latz. Chair Latz, Senator Limmer, yep, I agree with your interpretation. In line 48.24 of section 49 does indicate that a majority of the membership needs to first approve it. So you'd need that, and it's not just those who are present at a meeting. Line 48.17 indicates that they may sell. It's not a shall sell. If you get that threshold, and nothing in the section indicates that a cooperative couldn't set a higher voting threshold than what's stated there. So I believe that they could do that. If they want to create a supermajority requirement, you know, above the majority through their bylaws, there isn't anything in this act that would preclude that.
Ms. Primo, you have something you can add to this?
Mr. Chair and members, to answer Senator Limmer's question about the general flexibility for cooperatives to do additional things beyond the scheme set up in 308C, there's several lines that kind of work together to give them that sort of authority. I'd point to line 14.24. And I'll explain this after I cite those lines. Lines 16.20 to 16.21, and lines 17.8 to 17.9. And there may also be others, but essentially these all work together to set up a framework that as long as what the board, the members agree to is not inconsistent with the provisions in this chapter, that they can place additional processes around virtually anything in terms of the governance and the structure of the cooperative and the various rights of members.
Mr. Chair.
Senator Dibble.
And I'll also add, as Ms. Primo said, there might be other sections. If you look at 17.18 to 17.26 and 17.27 to 18.6, where quorum and voting requirements for members and for directors can be customized.
Senator Limmer, did you want us to pause a moment so you can read through what
No,
was
Mr.
just
Chair.
cited? Or do you have a
Mr. Chair,
follow-up?
I'm somewhat satisfied now. Thank you.
Senator Kroon.
Thank you, Mr. Chair. One of the things we had previously talked about was, I think it's on section 38, of member violation that could cause where the board may be required by the board to surrender the member's membership interests and occupancy rights, in whether or not there's adequate safeguards in place. And we had talked about perhaps an ADR or arbitration or some sort of mechanism to protect a membership interest from a board, a simple majority vote to basically kick somebody out and take away their shares. I couldn't quite get my head around a binding arbitration amendment that made sense to me that would work within here, so I kind of abandoned that thought. But how do you envision that scenario working with the bill as drafted? Does a member have a right to go to court, to dispute, or what? How would that work mechanically with the bill as it's drafted?
Senator Dibble.
Thank you, Mr. Chair. So it depends on the nature of the default, is I think the term of art here. If it's a financial default, there are a number of set provisions. I'll have Mr. Nemo take over in a split second here. If it's a violation, if it's a default against the governing documents, it's behavioral in nature. There's some other ways of dealing with that, that may or may not contemplate someone being made whole in terms of being able to receive their interest back. But Mr. Nemo and I talked about this a while ago, so he can provide a better response. So.
Mr. Nemo.
Chair Latz, Senator Kroon. So currently, without 308C, there are kind of two kinds of defaults, we would say, against organizational documents. One is monetary, one's non-monetary. So under the current law in Minnesota, if you're a cooperative housing project, you're subject to 515B, and 515B only regulates monetary defaults. Okay, so if you're not paying your, what we would call carrying charges, which is your proportionate share of the debt service on the master mortgage, utilities, everything else, and you go into default, there's a 515B articulates, under the bylaws, the cooperative can terminate your membership. They would then proceed with foreclosure proceedings as articulated in 515B. 515B says that if they don't redeem within the redemption period, the co-op can sell the membership interest for the amount of the debt, right? So if you have a $150,000 membership interest and the debt's $20,000, the co-op under 515B only needs to take $20,000 to satisfy it, regardless of how much equity that person has in or the value of the membership. If it's a non-monetary default, 515B doesn't regulate it. Neither does 308A, because 308A is a cooperative statute that can govern any kind of cooperative, housing, wind, electricity, farm. And so it doesn't address non-monetary defaults. nor does 308B. So what is happening, I think, for in large part, is the cooperative communities that do exist out there are writing provisions into their bylaws and regulations to deal with situations like this, to afford people an opportunity for a hearing before their rights are terminated, or occupancy rights are terminated. If it was a non-monetary default, then they would follow the eviction proceedings if the person didn't voluntarily leave under 504. So the other thing I would mention too is that, again, with Minnesota's home to, I think, the largest amount of senior housing cooperatives in the United States right now. Most of those co-ops are under a federal program, which is HUD, Section 213 of the National Housing Act. HUD heavily regulates these cooperatives and how they can operate to ensure that processes like this are in place. So to answer your question, the statute doesn't necessarily prescribe what must happen in a non-monetary default situation, but neither does any other statute in Minnesota right now in terms of a housing cooperative or condominium where there's a non-monetary default.
Senator Kroon.
Thank you, Mr. Chair. Two-part question. One, does 515B still govern monetary defaults under this bill?
Mr. Nemo.
Chair Latz and Senator Kroon, yes, it does, because 308C by its terms is still subject to 515B, and to the extent there's a conflict, 515B controls.
Senator Kroon.
Thank you, Mr. Chair. So for non-monetary defaults, I still don't see any protection or avenues for a member to get into court. You mentioned an eviction, but that would be at the very end of it, after a determination's already been made. What safeguards are in place at the point of that determination, whether or not a non-monetary default exists, and kind of the mechanism that says you lose your membership rights? Is there a way to get into court at that point under this bill for a member?
Mr. Nemo.
Chair Latz, Senator Kroon, a member would always have that right to do that. They could always pursue an action in court for specific performance or, other relief to be allowed to maintain their membership in the cooperative, argue their defense for why they're not in default, or what they will do to get out of that default situation. So that would always be available. But under existing statutory law, there isn't a statute in Minnesota that prescribes a process for that. They can do that. There's nothing that precludes them from doing it. And again, most cooperatives address those issues and a procedure through their bylaws because it isn't statutorily prescribed.
Senator Kroon.
Thank you, Mr. Chair. So if it's not statutorily prescribed, we could have different cooperatives having different processes for members losing their cooperative shares. And I understand that, I suppose theoretically, a member could go to court and seek an injunction or something if they're in the middle of a board procedure where they might be getting kicked out of their house. I mean, but typically that's not, we usually would want a process that naturally avails itself to some sort of determination that the member can take advantage of without just randomly kind of starting a lawsuit. And that's, I don't know if we want to prescribe that in statute or leave it up to every cooperative to kind of come up with that on their own. But it seems like the board does have an inordinate amount of power here to, at least theoretically, the baseline based on the statutory is just simple majority vote and you're out on a non-monetary default. There's no real process for the member to go through other than just drop everything, go to court and try to get an injunction. So I don't know if that's something that can be worked on in the next year. And I think I've identified that I don't have the perfect solution, or I'd have an amendment ready right now. But
Senator Cruin, I think you'd have to get past Senator Limmer, who doesn't want to be overly prescriptive.
right. Well,
We'll let you two sort that out. Go ahead.
thank you, Mr. Chair. I appreciate that.
Senator
And
Cruz.
I don't know what the right answer is here, because I don't want to be overly prescriptive either. But when it comes to losing your membership interest and losing your house, essentially, it seems like maybe we want to be a little more prescriptive, at least in that area. That was my general thought on that. Shifting gears real quick, my last line of inquiry here will be on page 22 with the damages on for occupancy agreements, lines 23 through 27. It just says damages there, but obviously there's lots of different kinds of damages. Does this give the board the authority to put in there any kind of damages rather than just actual damages?
Mr. Nemo.
Chair, that's Senator Kroon. I think that provision, my read on it is designed to allow a cooperative to assess late fees or fines or other damages if I'll give you an example. So somebody has a pet in the cooperative or spills red wine on the carpet, the cooperative can assess that to the member rather than, because all common expenses generally get apportioned out. If it's a 100-unit place, everyone's paying 1/100th. So a provision like this would allow the cooperative to assess damage caused by one individual to that individual, and it's common to incorporate that into an occupancy agreement or proprietary lease. The same as late payment. Again, if you've got a $20 million mortgage on the project and everybody is running 60 days late with their monthly payments, the cooperative's ability to service that mortgage and keep it out of default is going to be very precarious. And, you know, if there's insurance behind that mortgage, the lender and the party holding insurance is going to become nervous. So it's common to have provisions like that incorporated into proprietary leases or occupancy agreements, and that provision allows that to happen.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I understand it makes sense in terms of damage to property. I get that that person responsible should be responsible to pay actual damages, but it doesn't specify the type of damages in here. And what, you know, would this section here, this damages provision, would that, I mean, you mentioned fines and penalties, which I think are different than damages, but is that covered under this too? So if you're repeatedly parking where you're not supposed to, there's no real actual damages that you can articulate. Does it include liquidated damages or penalties or fines, or is that what this is meant to do? Is it only for actual damages?
Mr. Nemo.
Chair, that's Senator Kroon. I didn't draft that portion, so I'm not sure, but based upon my read of it in existing legislation that this act borrows from, it would be actual damages.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. Then, you know, it should probably say actual damages if that's the intent of it. Thanks.
Any further discussion on this bill as amended? Anyone else in the room wish to testify in connection with this bill? Senator Dibble, I have a note here that we should consider either sending it to the Senate floor or laying it over for possible inclusion in our omnibus bill. Do you have a preference?
Mr. Chair, I would prefer it go on to the floor.
All right. Senator Pappas?
Thank you, Mr. Chairman. I would move that Senate File 4053 as amended be recommended to pass and be referred to the Senate floor.
Is there any further discussion? To that motion, all those in favor say aye. Aye. Opposed? Motion prevails.
Thank you, Mr. Chair and members.
Thank you, members, and Senator Dibble. Senator Morrison will take up Senate File 4417 on Camp Ripley. Members, your packet of information is being distributed. It's a one-page bill, so it won't take long. And since we seem to be at the pace of 1 minute per page of the bill, then this should go very quickly, right, Senator Morrison?
Mr. Chair, I hope so.
All right, why don't you go ahead and describe your bill for us, please?
Thank you, Mr. Chair. Mr. Chair, members, Senate File 4417 is an agency bill that extends current authority that's been in effect at Camp Ripley since 1989 to be effective at other military installations, including the Arden Hills Army Training Site, the air bases at Minneapolis-St. Paul International Airport and Duluth, as well as armories around the state. As training for our military mission becomes more sophisticated, more high-value military equipment is stored at our training sites and armories, which makes it more accessible for acts of vandalism and mischief. Extending the violation to apply to all National Guard military sites will improve the ability of local law enforcement to more effectively respond to incursions. And with that, Mr. Chair, I will defer to my testifiers.
All right, if you go ahead and identify yourself, your affiliation, and give us your testimony.
Thank you, Mr. Chair and members. My name is Don Kerr. I'm the Executive Director of the Minnesota Department of Military Affairs. Senator Morrison did a great job explaining the bill. We have noticed a lot more activity around our installations away from Camp Ripley, particularly at Arden Hills. We did actually have 2 incursions of the fence in March, and having this coverage will actually simplify the local law enforcement's role in apprehending individuals that do intentionally trespass and potentially perform acts of mischief on our installations.
Thank you, Director Kerr. All right, and you, sir, go ahead.
Mr. Chair, I am Nicholas Slade. I'm the Deputy General Counsel for the Minnesota Department of Military Affairs and National Guard. And actually, Mr. Kerr covered all the things, so in the interest of brevity, I will add nothing.
Wise counsel, Mr. Counsel. Is there anyone else in the room wish to testify in connection with the bill? The intent here, members, is to lay it over. Any discussion from members of the committee? Senator Limmer.
I just have one question. On line 15 and 16, it talks about where these facilities would be, any facility owned or controlled by state or federal government for military purpose. Would that also include a recruitment office?
Mr. Chair, Senator Limmer, it would to the extent that our recruiting offices are typically inside our National Guard armories. We have a few storefront recruiting offices, but typically our recruiters office out of our armories, and so they would.
Okay, thank you.
All right, any further discussion? Senate File 4417 is laid over for possible inclusion. We understand it's going to end up in the Vets Omnibus Bill from the State Government Committee, but we needed to hear it in order for that to happen. And Mr. Slade, nice to see you again.
Good to see you, Senator.
Thank you.
Thank you, Mr. Chair.
Senator Morrison, Senate File 3427. Members, this is being distributed along with an A2 amendment. The plan here is also to lay this over for later inclusion in the Legacy Committee's omnibus bill. Senator Morrison, go ahead and describe your bill.
Thank you, Mr. Chair. Would you like me to discuss the amendment first?
Why don't you give us a summary of the bill
Sure.
first, and we'll go from there.
Okay, thanks, Mr. Chair. Mr. Chair, members, Senate File 3427 is a product stewardship bill that requires producers of shrink wrap to fund a product stewardship organization that collects and recycles boat plastic. Minnesota has the most boats per capita of any U.S. state, and in fact, the second most boats overall, well over 800,000. Many of these boats get shrink wrapped in the winter to protect them from the elements. Based on surveys done in other states about the percent of boats that are shrink wrapped and the average amount of shrink wrap used per boat, which is somewhere between 15 and 40 pounds, depending on the size of the boat, it's likely there's 6 million pounds of boat shrink wrap used every year in Minnesota, the vast majority of which goes into a landfill or an incinerator. But this plastic, luckily, is highly recyclable. So one of the most common plastic materials available. It's also easily recyclable into plastic lumber, construction sheeting, garbage bags, and back into boat shrink wrap. So that's kind of in a nutshell what the point of the bill is. The A2 amendment, Mr. Chair, was the suggestion of Senate Council just to tighten up the language. So the A2 removes the words "and sales" from line 5.23, bringing the bill in line with current Minnesota law. Under statute, section 1337, trade secret information is defined, but sales information is not. And sales information is captured within the current definition of trade secret information. So that's what's contained in the A2.
Ms. Primo, could you tell us the provisions in the bill subject to this committee's jurisdiction?
Mr. Chair and members, that would be on page 4, subdivision 9, which confers immunity from liability for certain purposes, and page 5, subdivision 15, which provides the date of classification.
Is there anyone in the room that would like to be heard in connection with the A2 amendment at this time? This is the amendment that's deleting the word "and sales" from the data classification provision. Not seeing anyone approach. Senator Carlson, would you like to move that amendment? Senator Carlson moves adoption of the A2 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. To the bill as amended, anyone else in the room want to talk about the whole bill? I will note it's my state rep that's carrying the bill in the other body. I could have given the presentation by Senator Morrison by heart because I've heard it at many community meetings already. To the entire bill, subdivision 9 dealing with liability and what we just amended in subdivision 15, or anything else? Anyone else in the room want to testify? Any discussion from members of the committee? Senator Limmer.
Thank you, Mr. Chair. Senator Morrison, what does the industry think of your bill? Are they aware of it, and have they made any comment to you?
Senator Morrison.
Mr. Chair and Senator Limmer, yes, the industry recognizes that this is highly recyclable. There is already a recycler who does this work, and there are others in Michigan and Canada who are excited and poised for a dramatic increase in business.
Mr. Chair.
Senator Limmer.
Senator Morrison, so that's one producer of it. I would imagine there might be more than one somewhere, especially if we're requiring them to implement and finance a statewide product stewardship program. Are they jumping for joy over that? They're going to spend more money, or that is required by the state? Or is there any opposition to your bill?
Senator Morrison.
Mr. Chair and Senator Limmer, I actually have not been approached with opposition to this bill.
All right. Thank you.
Any further discussion? Not seeing any. Senate File 3427 is laid over.
Thank you, Mr.
Senator
Chair.
Morrison. Next bill, Senator Carlson, Senate File 4504. Welcome back to the table. A couple of previous testifiers. Members, the packet is being distributed. All right, so here. Members, the plan here is also to lay this bill over. State Gov plans to include it in their Veterans Omnibus bill. Senator Carlson, would you please give us the overview of your bill?
Thank you, Mr. Chair and members. This is an agency bill that clarifies access details of data that involve service members who may have committed crimes under civilian and/or military jurisdiction. It clarifies the sharing of data and also the circumstances where the data is shared without the need for judicial action. I have Mr. Don Kerr, the Executive Director of the Department of Military Affairs, to provide more perspective and answer questions.
Mr. Kerr.
Good afternoon again, Mr. Chair and members of the committee. I'm Don Kerr, the Executive Director of the Minnesota Department of Military Affairs. As the Senator stated, it is an agency bill. Our original endeavor here was to take two pieces of the bill that were separated by a data clause and put them together next to each other because there was confusion about whether the data clause moderated either one of the other two parts. So we made that adjustment, and then we got a recommendation from staff in the other chamber to add this cross-reference to Minnesota Statute 13.02, which takes up the additions in the back part of the bill. And then just some other clarifications to language regarding some of the data that we wish to collect and clarifying our role. There's another bill that moved that had to do with designating our agency as a law enforcement activity to allow the sharing of data. This is kind of related to that, Mr. Chair. You'll recall that came through here about a week and a half ago and was passed to general orders. And so this is our attempt to clean this statute up and clarify some of those other provisions.
Ms. Primo, can you identify any particular provisions we ought to pay attention to within our jurisdiction?
Mr. Chair and members, I think it ends up being the whole bill. There are data provisions in there, but there is also a sort of public safety piece in Section 2 as well.
Mr. Slade, did you have anything else to add, or are you there to answer questions?
I'm here to answer questions, Chairman.
Anyone in the room wish to testify in connection with this bill? Not seeing any. Any discussion from members of the committee? Again, not seeing any. Any final words, Senator Carlson?
Only that this was a complicated bill that I think was made simple by more explanation, and I'm looking forward to your support.
All right, Senate File 4504 is laid over. Thank you, members.
Thank you, Mr. Chair and members.
Thank you, Mr. Chair.
All right, members, we're going to go next to Senator Hoffman's bill on parental rights. The packet is being distributed. We'll welcome Senator Hoffman to the testifier table. And the plan here is to re-refer the bill to the Committee on Health and Human Services. Members, this is the original committee to which this bill was referred. There is an A1 amendment in your packet, which would be considered an author's amendment. Senator Pappas moves adoption of the A1 author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Ms. Primo, is it fair to say the entire bill is within this committee's jurisdiction? Senator Hoffman, would you like to tell us what your bill does?
Mr. Chair and members, first of all, thank you. It's been 9 years since I sat in this chair looking at you wonderful folks in Judiciary, and it reminded me of this story, Mr. Chair. The last time I was in front of you, we were celebrating the Cheese Puff Day, and I had brought a whole bunch of cheese puffs to the committee, because I remember the story that Senator Limmer talked about, if you're in front of Judiciary and it's your first one, or maybe it was Sandy Pappas who said that. So I brought the cheese puffs. Well, today, Mr. Chair, it's National Chocolate Mousse Day, and I kept thinking to myself, how in the heck am I going to get a moose to come through any of these doors? So with that, I wanted to let you know I was trying to be due diligence in keeping with tradition of why we're in front of your wonderful committee.
Senator Hoffman, you are welcome to deliver chocolate mousse to my office after the hearing is done.
Thank you. Thousands of parents, Chair Latz and members, thousands of parents with disabilities are successfully raising children all over this country, and many right here in Minnesota. In fact, we have many well-adjusted adults in Minnesota who are raised by parents with disabilities. Yet, because of fear and misconceptions about disability, that's ableism that's built in here, parents with disabilities experience disproportionately high rates of child removal or loss of parental rights. The National Federation of the Blind in Minnesota brought this bill to me because of their direct experiences in which parents' rights have been questioned on the basis of blindness. Imagine that. We know this happens with other disabilities as well. And this legislation does not require new service or additional funding. Rather, it sets a framework of procedural safeguards to be used if disability is raised as a factor in an adoption or a custody case, Mr. Chair. And so there's some safeguards, and I just want to highlight those, and then I'm going to turn it over. Any petition to deny or limit parental rights must not be based on the presence of a disability, but rather on a parent or prospective parent's specific behaviors. Number two, the party raising the concern has the burden of proof that specific behaviors will endanger the child, not the other way around. Number three, the parent must have the opportunity to demonstrate how the use of supportive parenting services, and I'll give you an example, mentoring. There's the parent-to-parent initiative that is done through the Minnesota Department of Health and HRSA, Title V. We've had it for many, many years. Those techniques alleviate any concerns because it's a parent-to-parent piece. Number four, if a denial or limitation does occur, the court must state in writing the reasons for the decision, including why supportive parenting services could not be used to prevent the denial or limitation. And I just wanted to let you know, Mr. Chair and members, additionally, there's parental rights legislation in Alabama, Arizona, Colorado, Connecticut, Georgia, Hawaii, Kansas, Maryland, Missouri, Nevada, Nebraska, New York, South Carolina, Tennessee, and Utah. And the testifiers I have is Corb O'Connor from St. Paul, and then Serena Decker, and I think Kaylee Decker is here from Maple Grove if there's time permitting. So, Mr. Chair, thank you very much.
Thank you, Senator Hoffman. We'll hear from Corb O'Connor from St. Paul.
Mr. Chair, thank you. I'm Corb O'Connor. My pronouns are he, him, and his, and I'm the president of the National Federation of the Blind. We're an all-volunteer organization that is the transformative membership and advocacy organization that's been working in the state of Minnesota since 1920. Senator Hoffman did a fantastic job describing the details of this bill. But let me tell you, as a disabled parent of a blind child, I want to tell you the story of one of our members. She came to the United States in 2002, learned English, learned skills as a blind person, got her GED, bachelor's and master's degree, and now serves as a senior official in state government. And yet, after the birth of her first child, she was visited by a social worker. Now, being new to this country, she thought, this is so nice. The U.S. has people visit you as a new mom. And this social worker observed her for several days, watching her feed, play with, change her child. And on the third visit said, you're doing great. I don't have to worry anymore. Well, of course there was no need to worry. This mom had done everything that she needed to do. But we know of other instances where social workers were not as generous with those new parents. We know of parents who have been separated from their children only because of blindness and because of the misconceptions that are out there. And so I urge your support of this bill to ensure that parents with disabilities have the same rights as all other parents to raise their children and to keep their children with them after their birth. Thank you, Mr. Chair.
Mr. O'Connor, thank you for your testimony, and your child waved at us after you mentioned that. Would you like to introduce your child to us?
Come on over. Tell them your name.
Tell me your name.
I'm Silas.
Silas
Hello.
O'Connor.
Silas, how old are you?
8.
Well, we're very glad to have you here. Welcome to the Senate Judiciary Committee.
Thank you, Senator.
Thank you. All right, we also have, wasn't sure if it's Serena or Callie who intends to testify,
Serena, you want to go first?
or both, perhaps. Go ahead and
Well, we're
introduce
together,
yourself.
so that's how we talked about it, okay?
Hi, I'm Serena and I am a hockey player.
Hi, I'm Callie. I'm a hockey mom.
I'm in 3rd grade and I love to read. I like trying new things and going on adventures.
I love to travel and explore new places and cultures. I'm a blind parent.
I'm a child of blind parents. My mom taught me how to read very well. My dad helps me with my math homework. I read what's on the page. Wait, what?
Go ahead. You read what's on the
Oh, I read what's on the page and we work together. My parents take us on trips like Mexico. They use their long white canes to help them navigate safely. On this trip, I had no idea where we were going, but my parents got us where we were going and we had a blast.
We're the same as everyone else and just do some things a little bit differently. We can't drive, but we get to sit in the back and chat with our kids when we're on ride shares. We cook meals and maintain a home. We play games with print and braille and read books with print and braille with them.
I have the best parents ever, not because they are blind, because they are awesome. Let's score a goal for blind parents and families in Minnesota.
Thank you.
And thank you for your testimony. And Serena, that was terrific. How old are you?
9.
9. Welcome to the committee, to the state senate. And to your mom, too. She's pretty awesome, you're right.
Thank you.
All right, any questions from members of the committee for any of our testifiers? Senator Westland.
Senator Hoffman, thank you for bringing this bill. I think this is a wonderful bill. My only feedback to you as a family law attorney, and I was discussing this with Ms. Primo, is I think on 2.27, you're proposing to amend Section 518.1751, which is actually a part of the statutes that deals with the appointment of a parenting time expediter. And we were thinking it would probably be better placed in 518.17, which is where the best interests of the child factors and the sort of the process the court goes through in awarding custody and parenting time. I'm not sure that it should go in the parenting time expediter part. That's just sort of like a mediation type process. And I think your aim was really more for the court in making a custody and parenting time decision to have this language to consider.
Senator Hoffman.
Thank you, Mr. Chair. And, you know, the argument about person-centered, child-centered, whatever, when it comes to that discussion, and I'm reminded of Dr. Robin McWilliams from Vanderbilt University, when he was at the Frank Porter Graham Early Childhood Development Institute, talked about if you don't have the conversation and the contextual argument of the family, right, family-centered, right, then you're missing the actual argument itself. And in this case, I think it's when you're telling it's going to be specifically on the child, right, and not the contextual argument of the family unit itself, you might be losing on something. So I would fall back. You're an attorney. You argue this stuff, Mr. Chair. I'm not, but I do know Public Law 99-457 than anybody better in this Senate. But I won't go down that road if you want to. But in this case, the contextual argument is about that. So having said that, if you feel that that is not the intent of that, then, you know, we have, the next stop is HHS, which I serve on, right? There's many steps to have this, and maybe Mr. O'Connor, you know, if you talk to the folks that understand this, because their lived experience is different than your lived experience, right? My lived experience is different than your lived experience. And so in this case, I hear what you're saying, But I think that that should be something that should be talked about at the next stop, or if you have any idea of what that would look like. I do not want to lose the contextual argument that it has to be family-centered and not specific to an individual.
Senator West?
Yeah, and just to be clear, I think we're on the same page.
Good.
But the statutory reference is for the appointment of a parenting time expediter. The part that you're putting it in, which is a very narrow situation where if parents have a disagreement, the court can order a parenting time expediter to make decisions for them. And I don't think that's what you're trying to do. I think what you're trying to do is when the court is making a family decision about allocating parenting time and custody, that they have to consider factors in doing that. So I think it's just the parenting time dispute resolution piece is about a process for disputes and how to resolve them outside of court versus how to make the determination initially for custody and parenting time. So I agree with you. I'm just saying I think this is very limited, a very limited section in the dissolution of marriage statutes, and I don't think it's probably where you intended for it to go. And I think what we want is when the court is making a custody and parenting time determination, we're telling the court that this is what they have to follow in making that determination. And the parenting time expediter part of the statute it's literally only about appointing someone to mediate disputes.
Senator Hoffman, the line 2.29 opens with, "The court shall not deny or restrict a parent's parenting time or custody due to the parent's disability." So it seems like what Senator Westland is saying is that belongs in the parenting time and custody section that directs the court to handle it. Ms. Primo seems in agreement and can make the change easily here since it's not a substantive change.
Thank you, Mr. Chair.
Can we go ahead and
That was
take
my-
care of that here, Senator Hoffman?
I'm good, Mr. Chair. If it's not a substantive change, it doesn't change what the outcome that we want. Clearly on this doesn't change the role going forward, but rather it's just a technical fix within the construct of that. Yeah, I'm fine with that.
Ms. Primo, could you describe the proposed amendment?
Mr. Chair and members, page 2, line 27, delete 518.1751 and insert 518.17. Page 2, line 29, delete 8 and insert 2A.
Senator Westland moves that amendment. Any further discussion? Not seeing any. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right, any further discussion? Anyone else in the room want to testify in connection with the bill? Any further questions or comments from members of the committee? Senator Westland moves that Senate File 5097 as amended be recommended to pass and be re-referred to the Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails.
Thank you, members.
Thank you all.
Thank you, Mr. Chair and members.
Senator Pappas, Senate File 3787. Members, the packet is being distributed. This bill came to us from the Labor Committee. The intent is to send it back there since they have the money that will be involved in this bill.
Thank you, Mr. Chairman.
Senator Pappas.
Actually, the money was already appropriated last year.
Even easier.
It's not new money.
We'll still send it back to
Send it back anyway. Thank you, Mr. Chair and members. So Senate File 3787 modifies the Earned Sick and Safe Time law passed in the 2023 legislative session. The bill provides, just briefly, the bill provides DLI with rulemaking authority related to ESST and strengthens penalties against employers that do not provide ESST or penalize employees seeking to use ESST. In addition, the bill requires that all accrued sick time earned by an employee includes earned sick and safe time protections and not just the minimum amount of ESST required under the law. It modifies the definition of the rate of pay that an employee is required to receive when being paid for ESST, adds bereavement leave to the allowable uses, and modifies documentation requirements for employees. The bill also modifies the earning statements that employers are required to give employees, seeking employers greater flexibility to meet the requirements. We've tried to meet with a number of people to learn what some of the problems are, and some of them will be solved by the bill includes rulemaking authority, which the department did not have through kind of a oversight last year. That's what the dollars are in the bill, is to pay for the rulemaking authority. Mr. Chairman, I believe it might be section 1 and 3. That is before this committee, but the staff can clarify that.
Yeah, I'm going to ask Ms. Primo to identify the sections before this committee. Ms. Primo.
Mr. Chair and members, the bill was sent to us because of sections 1 and 3. There may be additional provisions, so based on documentation that trigger additional liability on the employer, for example, in section 12.
Mr. Chairman and
Senator
members, I
Pappas.
have Jessica Groves, Director of Labor Standards from DLI, with me if there are any technical questions. Did you want to make a statement?
All right, I do have some indication that we have some testifiers on Zoom as well that would like to be heard on the bill. So if we'll bring up our testifiers, David Martin and Reva Parker. Mr. Martin, if you'd go ahead and identify yourself and your affiliation, welcome to the Senate Judiciary Committee.
Great. Thank you, Chair Latz. I appreciate that. My name is David Martin, and I'm the Senior Legislative Representative for the Airline Pilots Association International. We represent about 78,000 pilots in the U.S. and Canada, and I wanted to thank you and the committee and Senator Pappas for correcting the language which wrongfully carved us out of the original ESST bill. I wanted to make myself available to answer any questions you might have. Thank you.
Thank you, Mr. Martin. Reva Parker, you go ahead and identify yourself, please, and your affiliation, and present us with your testimony.
Good afternoon. Thank you. My name is Reva Parker, and I'm the Vice President for Labor and Employment Litigation at Airlines for America, the trade association representing the nation's largest carriers. Thank you for allowing me to testify today, and I appreciate the accommodation to appear virtually. I'm here to address how Subdivision 7 of Senate File 3787, the removal of the exemption for airline flight crews, is preempted under federal law. Unique among employers, air and rail carriers are governed by the Railway Labor Act, which envisions nationwide employment rules in order to avoid disruptions to national transportation networks. As a practical matter, this means that all members of an airline work group are under a single set of work rules for that employer. Additionally, the Airline Deregulation Act contains an express preemption clause that prohibits states from enacting laws related to a price, route, or service of an air carrier. In Morales v. Transworld Airlines, the Supreme Court held that this preemption is broad and operates on laws of general applicability having a direct or indirect significant impact on prices, routes, or services. The Eighth Circuit follows the Supreme Court's significant impacts test. Paid sick leave laws have been twice evaluated under this standard and both times found to be preempted. In Delta v. New York City, the court found that the city's paid sick leave law's potential impact goes directly to the availability of flight attendants and thus on-time flights. The court held that the act's relation to the airline services is significant enough to trigger preemption. In Afray v. Campbell, the court found the Massachusetts paid sick leave law preempted, concluding it has a clear and direct impact on the availability of the airline's labor force and therefore on their ability to provide these services to customers. The one contrary precedent applied the wrong test. In Washington state, the court applied the Ninth Circuit's binds two test in rejecting preemption. Notably, the Washington case preceded the other two, which considered and rejected the Washington precedent, noting that no other circuit has adopted such a narrow standard. As this committee is well aware, Minnesota is in the 8th Circuit, which, like the 1st and the 2nd, applies a significant impact test for ADA preemption. Accordingly, this bill, as applied to airlines, is preempted by federal law. We urge you to retain the airline exemption. Thank you for the opportunity to testify on this issue, and I'm happy to answer any questions the committee may have.
Thank you, Ms. Parker. Appreciate your participation today. Any questions from members of the committee for Ms. Parker or Mr. Martin? Senator Kroon.
Thank you, Mr. Chair, and my comments are on the omission of, or putting the airline employees back into this bill. I think we got it right the first time. I think federal preemption applies, and we're probably going to have another lawsuit if we pass this bill as drafted. I guess, you know, that's my initial impression, but I'm just kind of wondering how airline employees, in particular in-flight crews, how that relates to the earned safe and sick time benefit. And so if, I don't know, maybe the question would be for the agency, but in those types of situations, how is that applied? How does the time accrue? When would the benefits be able to be used? Because we're talking about employees that are potentially are not even based in Minnesota. They may be based out of some other airport and they fly into Minnesota, they fly out of Minnesota. How does the sick time benefits accrue and apply to those types of employees?
Senator Pappas.
Mr. Chairman and members, because this was exempted last year, DLI has not had an opportunity to provide guidance in this area. So during the rulemaking process is when they would determine what would be applicable. We really do have lawyers in disagreement here. So we had a number of court cases that determined that crew members and pilots should be exempt, and then the airline pilots' lawyers disagreed with that, and there was a court ruling, I believe, out of Washington that said they were not exempt. So we have kind of competing lawyers, and DLI, I'm answering this because DLI is neutral on this topic. So, you know, unless the committee wants to make a change or the legislature at some point, it probably will end up in the courts.
Senator Kroon.
Thank you, Mr. Chair. Well, it's hard to, I mean, we don't know how DLI is going to implement this. I guess as a general matter, flight crew absences would seem to have the potential to cause service disruption, which is the whole point of, or not the whole point, a very large point of the Airline Deregulation Act. And I understand that there are conflicting court decisions, but as if I heard the testifiers correctly, and maybe the one from the airline pilot union can correct the record, but it sounds like the Washington case was applying a different standard that the Ninth Circuit uses, whereas Minnesota's in the Eighth Circuit, and the two cases that have applied that standard have both found that the sick time are preempted. But maybe I misheard that, but if one of the online people could correct me, is there any court that has ruled that this is not preempted, that's applied the standard that's used in the Eighth Circuit?
Senator Pappas.
Mr. Chairman, I think Mr. Martin could probably respond to that since he's online with us.
Mr. Martin.
Sure, happy to address that. Thank you for the question. So the Ninth Circuit is the law of the land. The airlines took that case to the Supreme Court and were denied cert last year, I believe it was. So it stands as the law of the land right now. So airline employees should not be exempt from leave laws. The preemption clause in the Airline Deregulation Act is very clear. It's very narrow. As she said, it's limited to routes and services and frequencies. part of the argument that was used was that, if there are absences, well, airlines already accommodate that by having crews on standby. I hope that answers your question. Thank you.
Senator Cron.
Mr. Chair, thanks, Mr. Chair. I want to make sure I heard you right. You claiming that the Ninth Circuit decision is the law of the land because the Supreme Court denied cert? Is that what I heard you say?
Mr. Martin.
It is, sir.
Okay, well, I'll disagree with you on that point. That doesn't make it the law of the land. Supreme Court can deny cert for all sorts of reasons. Most of the cases don't reach to the Supreme Court. And if there's other authority in the Eighth Circuit, or if the Eighth Circuit has applied a certain test in these preemption cases, and other cases are applying that test, they would have more precedential authority than the one coming out of the Ninth Circuit. And I would also dispute what you said about service, having that definition, because the court cases I'm reading, the service under the ADA represents more than that. Bargain for or anticipated provision of labor from one party to another, ticketing, boarding procedures, provisions of food and drink, baggage handling, all of these things are included under the mantle of service. It's not just simply a disruption, but I would argue even if it is a disruption, that employee absenteeism will directly affect whether or not flights are statistically go off on time or not, which is the whole purpose of the ADA and why this should be federally preempted. And like I said, I think the legislature got it right last year, strictly from a legal standpoint. I think this is a lawsuit that we're going to lose. I won't get into more of the details here on why I think that, but see if there's any other questions that any of the testifiers can answer.
Could I respond to that, Senator?
Sure.
Yes, Mr. Martin.
Thank you for the opportunity again. So again, airlines make accommodations. They anticipate that there will be absences. I'm sure you've all been on a flight where there's been weather delays and crews have timed out. And you've heard the announcement over the PA that they're waiting for the crew to show up. There are crew that are scheduled every month that are available for standby, flight attendants and pilots. It's been shown that the disruptions would be negligible. So again, including pilots and flight attendants or flight crew in the ESST is not going to lead to increased absenteeism or disruptions in flight. Thank you. I appreciate it.
Mr. Chair.
Senator Cron.
Thank you, Mr. Chair. Well, that's exactly opposite of what the court found in Air Transport Association versus Campbell out of Massachusetts, where they said there was a whole trial on this specific issue, and the court made findings about how it absolutely will impact that. And the fact that there are standby flight attendants on hand, if you increase that, then you have to increase the standby flight attendants, which isn't economically feasible. And also, I'm also concerned about Minnesota being one of, if this is not federally preempted and you have many states doing different sick time, and it's not, and they're all interpreting that different when it applies, it could absolutely become an administrative nightmare. And I think the Dormant Commerce Clause would eventually apply too. So this law could get struck down under federal preemption. It could easily get struck down under the Dormant Commerce Clause as well. This is something that should be regulated by the federal government. And I'll just leave my comments at that. Thanks.
Any further discussion? Senator Howe.
Thank you, Mr. Chair. And Senator Pappas, on line 6.7, it excludes independent contractor. And I'm not sure, but maybe you can help me. I thought there was multiple definitions in state statute of independent contractor. And I was just wondering if there's a specific section or a definition of independent contractor for this, or is it pertain to all definitions of independent contractor in state statute?
So I'm going to, invite you to answer the question, but please be very, very succinct, as
Okay.
this provision is not before this committee's jurisdiction, and that's also existing statute. So it's not even proposed to be changed. If you have a
Mr.
quick
Chairman,
answer, please go
I'm
ahead.
going to turn it over to Ms. Gross on that.
Ms. Gross.
Thank you for the question. Thank you for the question. The statute doesn't specify which test we would use to determine if someone is an independent contractor. So we would be looking at the individual to see what sort of work that they perform to determine which test would need to apply.
All right, I understand Ms. Parker had something to add, but at this point, this provision is not within our committee's jurisdiction, nor is there any change proposed in this bill to that language in current law. So I'm just going to move on to the next topic if there is any. Senator Seeberger.
Thank you, Mr. Chair. I'd like to offer the A13 amendment, and I've had discussions with Senator Pappas about this, and our conversations are still ongoing. Part of the issue, what the A13 amendment does, and I believe this is within our jurisdiction, is it exempts paid-on-call members of a fire department. So under the public safety jurisdiction, we would exempt paid-on-call members of a fire department. And the reason why I am seeking to make this change and why I think it makes sense is that being a paid-on-call member of a fire department is kind of unlike any other employment relationship that I can think of. And the earned sick and safe time statute really doesn't fit within this employment model. I've indicated to Senator Pappas, and I'm working on other legislation to be introduced in a future session that provides comprehensive protections to members of fire departments, specifically around loss of service credits. So the valuable piece when you're on a paid-on-call fire department is being a member in good standing. It's a service credit. It's not the pay. And it's, Senator Pappas and I had a discussion of, what is it, when are you working, and when would this count toward, when would you accrue earned sick and safe time, and when would you use it? And if you're not paid for working, it's not the pay that you miss, it's the service credit. It's being a member in good standing. So for example, I'm a member of a paid-on-call fire department, and my obligations include 2 overnight 8-hour shifts a month that I have to do to be a member in good standing. I'm not paid for that. I change into my uniform and I go sleep on a couch down at the station for no pay, but I have to do it because that's part of what is expected of me to be a member in good standing. Why it matters to be a member in good standing is because for a firefighter, that's how you qualify for your relief association, your pension. For me personally, my department has a scholarship program, and I'm utilizing those funds to pay for my older son's college. If I'm not a member in good standing, I don't have access to those scholarship funds. So different departments build in different benefits based on whether you're a member in good standing. Whether you're a member in good standing relies on whether you've fulfilled different requirements to be a member in good standing. Usually it's attending a percentage of calls, doing a certain number of hours of training, and on my department it includes these unpaid overnight shifts and certain unpaid activities like staffing a pancake breakfast. So things like that don't translate easily into work hours, and earned sick and safe time doesn't compensate a paid-on-call member for what they're truly missing when they're missing work, which is the service credit. So what I'm working on is a bill that kind of addresses that more in the context. I had a conversation earlier this session with a female firefighter who was missing service credit because she'd had a baby and was wasn't back in 100% physical condition at the time she returned to work. So it's taking into consideration greater areas of need within fire departments so that members can take pregnancy leave or sick time or whatever it might be and not lose service credit or be able to gain back service credit in certain situations. So with the commitment that that's what I'm working on to get at folks who serve on fire departments, both paid on call and career, A13 takes only paid on call members out of the equation for earned sick and safe time. Number one, because none of the chiefs know how to calculate it. There's really no guidance on how to do it. But more importantly, number two,
it's the service credit, not the pay, that really is the most value to paid-on-call members of a fire department.
Mr. Chairman.
Senator Pappas.
It's really helpful to have somebody with lived experience on our committee, and I think Senator Seeberger is the first person that actually could clearly explain this to me and others. You know, in general, the professional firefighters have not wanted to exempt the paid-on-call because in some situations you could accumulate hours that could be credited toward your earned sick and safe time as you gain 30 hours to gain your first hour if you become then a professional firefighter. But I doubt if Senator Seeberger has any plans to do that, and probably many of them don't. So this is, I'm not crazy about an exemption, but I don't think we've kind of found a perfect solution for this. So it's something we'll keep working on, but in the meantime, if the committee would like to adopt this amendment, I've committed, Senator Seeberger and I are committed to continue working on it when it's back in the Labor Committee.
Any discussion on the 813 amendment? Senator Howe.
Thank you, Mr. Chair, and Senator Pappas and Senator Seeberger, having come from that same environment, I've served both career and have been a chief in a paid-on-call department, so I get it. And I've talked to numerous cities that have trying to figure out the challenge on how to actually ascertain how to implement this. So I think there's probably some cities where it would work. I think there's other cities like, and departments, because none of them are the same. They're all different. Every department has different requirements and different shifts. So I think it's wise to maybe take a pause and take a deeper look at this before we try to make them figure out how to make this work. Thank you, Mr. Chair.
Any further discussion on the 813 amendment? Anyone in the room want to testify in connection with it? Not seeing any. Senator Seeberger moves adoption of the 813 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion on Senate File 3787 as amended? Anyone else in the room want to testify in connection with the bill as amended? Not seeing any. Senator Pappas moves that Senate File 3787 as amended be recommended to pass and be referred to the Senate Committee on Labor. All those in favor say aye.
Aye.
Aye. Opposed? No. Motion prevails. All right, members, we're going to go to Senator Oumou Verbeten, Senate File 4387. Members, the packets being distributed, we will also be distributing a letter in connection with this proposal. This bill is, the Judiciary Committee is the first committee to hear this bill. So the A3 amendment that is in your packet is an author's amendment. Senator Oumou Verbeten moves adoption of the A3 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Oumou, the expected outcome here is for the bill to be referred to the Committee on Human Services. So, Senator Oumou Verbeten, please tell us about your bill.
Thank you, Mr. Chair, members. Senate File 4387, Minnesota Connecting Families legislation is something I'm really passionate about because healthy, close-knit families are the cornerstone of safe communities in Minnesota. And we have an opportunity to enact a simple policy that will improve the lives of countless hardworking, tax-paying families in communities across our state. The prison telecom industry is a billion-dollar industry, and it's dominated by just a few private equity-backed corporations that make hundreds of millions each year exploiting family ties. For years in Minnesota, we've been complicit in this exploitation by collecting commissions on communication revenues. We stopped that practice last year with the first iteration of Minnesota Connecting Families and eliminated the fees on phone calls. And I'm very grateful to the Department of Corrections and the administration for also helping lead that effort. But we still have a way to go in making sure the fees on all communication services are eliminated. And the personal toll that our families experience is really immense. 1 in 3 families with an incarcerated loved one actually go into debt just to keep in touch. They face these really unimaginable choices of either going in debt to stay in contact with their loved ones or forcing their loved ones to spend time in prison, increasingly alone and isolated. And without that connection, there can be severe physical, mental, emotional ramifications, both while a person serves their sentence and after. And those can amplify over time, leading to a breakdown of familial bonds and higher recidivism rates. Again, last year we took that important first step by eliminating the fees for phone calls in our state prisons, and the bill before you would eliminate those fees on all forms of communication. That would include things like video calls, emails, electronic messages in all of our state facilities. Communication is a lifeline, and it creates really positive ripple effects for families and our communities as a whole. Regular contact with loved ones increases the likelihood of engaging in constructive behaviors. It lowers violence and makes the carceral environment safer for correctional staff and incarcerated people alike. Families are the support system that incarcerated people need to succeed when they go home, and we know that 95% of them will. Communication strengthens the relationships that people need to ensure they're successful and that they can thrive after release. But this bill is not only the right thing to do, it's effective and it's also fiscally responsible. Taxpayers are already paying for the cost of communication. But under a model where there are commissions, there's an inflated rate that we're paying. And there's also a small subset of taxpayers, those folks with loved ones that are incarcerated, who really bear most of the cost, and they're the least able to afford it. Under the model that my bill is proposing, the Department of Corrections is really incentivized to get lower rates rather than the highest rates. And I know the department is committed to this work and has been exploring new vendors. They have an opportunity to do that with a new contract coming up to renegotiate rates, either with a vendor they've worked with in the past, to find a new vendor that can provide those communication services at a better rate. And we know, looking at what other states are doing, that there are better rates available. We can just go to the market to find folks who are able to provide these services at a better rate and then ultimately save taxpayers money. So in closing, I just want to say that this can free our families from the burden of really exploitative corporate practices. It can prevent families from going into debt just to stay connected and keep our community safe at the end of the day. Thank you.
Thank you, Senator. We have some testifiers here. We'll just go in the order that I've got them on the sheet. I have Andrew Lama from Worth Rises is, I believe, on Zoom. Mr. Lama, if you go ahead and state your full name and your affiliation and give us your testimony.
Thank you, Chair. Thank you, Committee, for your time this afternoon. My name is Andrew Lama, and I'm the Government Affairs Specialist at Worth Rises, a national nonprofit dedicated to ending the exploitation of people impacted by incarceration. We have helped jurisdictions across the country pass and implement policies that make communication free for incarcerated people and their support networks, including in California, Connecticut, Colorado, Massachusetts, New York City, San Francisco, San Diego, Miami, and still others. And we are currently supporting similar campaigns in over a dozen states and counties. With this legislation, Minnesota has the opportunity to join these other jurisdictions on the forefront of the national movement to provide overdue relief to millions of families with incarcerated loved ones by simply making communications free. Minnesota made significant strides to support free communications for confined people and their loved ones last year by making phone calls free in the state prisons, but there is still significant work to be done. The Connecting Families Coalition has submitted written testimony before you all with more detail in favor of SF 4387. Minnesota families currently pay the state's telecom vendor, Securus, an estimated $1.5 million per year, and a separate telecom vendor, Global Telink, $150,000 per year, each year to communicate with their incarcerated loved ones. This money comes directly from the parents, spouses, children, siblings, grandparents, friends, and others supporting incarcerated Minnesotans. Families are often forced to choose between paying for basic necessities such as housing and food and paying to hear the voices of their incarcerated loved ones. In fact, 1 in 3 families, as the senator noted, with an incarcerated loved one goes into debt trying to stay connected, and 87% of those bearing this enormous financial burden are women. In Minnesota, families must pay 5 cents per minute to call confined loved ones, $3.50 for a video call, $1.20 for a 15-second video message, or 40 cents per email. For every 40-cent email, the state profits 5 cents from commissions, and similarly, the state profits 15 cents per $1.20 video message sold to incarcerated people and their loved ones. In total, the state receives about $20,000 in commissions annually paid for by families of incarcerated people. The support that families provide their incarcerated loved ones can show how successful a person is both during and after incarceration. It increases hope, reduces desperation, and encourages positive behavior, which in turn reduces violence and improves the correctional environment for incarcerated people and correctional officers alike. One study showed that verbal and physical assaults decrease by 20% when incarcerated people have regular calls, and rule violations decrease by 27% when those calls are with their children. Further, incarcerated people who maintain connection with their family, community, and support network during their incarceration have a better chance of successfully reentering community upon release. With their family's help, they are more likely to secure housing and employment and generally have transition support. This increased success also translates to lower recidivism and increased public safety. Our very own Minnesota Department of Corrections studied the impact of video calls and showed a decrease of more than 20% in recidivism across all crimes, including violent offenses. Decreasing barriers to accessing critical communications like video calls by making them free would only bolster the rehabilitative efforts of the Department of Corrections. Minnesota can access significant savings directly paying for communications of incarcerated people. For example, with respect to phone calls, where they cost 5 cents per minute, there are more competitive rates offered in Illinois, where families pay less than a penny, New Hampshire, where it's a penny, 1.2 pennies, as same in Dallas. With respect to e-messaging, where they cost 40 cents in Minnesota, in Maine, they're 2.5 cents, and in Colorado, they're 5 cents. With respect to video calls, where in Minnesota, they're 23 cents per minute, in Montana, they are 15 cents, and in Michigan, they are 16 cents, with one provider offering the state of Virginia or Commonwealth of Virginia 10 cents per minute.
Mr. Lama, I'm going to ask you to wrap it up as we have 3 other testifiers and time for discussion as well.
We expect Minnesota to negotiate better terms with its vendor and explore some innovative models that are being used to further bring down costs. We urge the committee to vote yes on SF 4387. Thank you so much.
Thank you for your testimony. Anna Odegaard, Fines and Fees Justice Center, is present in person. Ms. Odegaard. Go ahead and state your full name and your affiliation and present your testimony.
Thank you, Mr. Chair. My name is Anna Odegaard, and I am a senior advocacy and campaign strategist for the Fines and Fees Justice Center. Fines and Fees Justice Center is grateful to this committee for hearing Senate File 4387, and I appreciate the opportunity to testify. We are a national hub for information and advocacy for fines and fees reform. Fines and fees in the criminal justice system hurt millions of Americans, entrenching poverty, exacerbating racial disparities, and trapping people in a perpetual cycle of punishment. Our mission at Fines and Fees Justice Center is to ensure that fines are imposed equitably and to eliminate all user fees in our justice system, including those charged for communications in jails and prisons. The Connecting Families campaign asked FFJC to testify today, and we urge support for this important measure, as we've supported similar bills in other states, as Mr. Lama mentioned. Enabling Minnesota residents to communicate with their incarcerated loved ones in state correctional facilities would have a meaningful and direct impact on the residents of Minnesota, and equally important, this is an evidence-based strategy to reduce recidivism, increase successful reentry, and make incarceration safer for all. I don't want to duplicate excellent testimony by our author and by Mr. Lama, so I will just mention a couple of brief things. The National Coalition of Public Safety Officers supports free communication services in carceral institutions because their studies show that it improves safety inside prisons, reducing tensions and violence inside, reducing incidents by around 20%, and improving the work environment for the officers.
Additionally, within the first 5 years of release, incarcerated people with strong family connections are 25% more likely to cease criminal activity, helping to reduce jail populations and ease the burden on correctional staff. For those and many of the other reasons that Mr. Lama and our author mentioned, FFJC urges this committee to support this bill. And I just want to thank our author so much for championing this over the last couple of years. And thank you again for the opportunity to testify.
Thank you, Ms. Odegaard. Lorenzo Hurt from Tone Up. Mr. Hurd, welcome to the committee. Go ahead and identify yourself and your affiliation and present your testimony.
My name is Lorenzo Hurd with Tone Up. It's a nonprofit organization that we focus on reentry. Thank you, Chairman Latz and the committee. My name is Lorenzo Hurd, a formerly incarcerated individual. I know the pain of disconnect from loved ones. The high cost of prison calls meant my family often missed meals or skipped paying bills just to hear my voice, a choice no family should face. Isolated and unable to ensure their well-being, my mental health plummeted into depression. Sleepless night and relentless worry about their safety support hammered at me relentlessly. This reality is not just mine, it's shared by countless families unable to afford the luxury of a simple phone call. Let's champion free communication for prisoners to ease the emotional and financial strain on families, to foster reintegration, and to humanize our justice system. No one should sacrifice basic needs for a moment of connection. It's time for change. Let's make it happen. Support 4387. Thank you.
Thank you for your testimony. Appreciate it.
Thank you.
We have Commissioner Schnell from the Department of Corrections.
Good afternoon, Chair Latz and members of the committee. Paul Schnell, the Commissioner at the Department of Corrections. The DOC shares the priorities reflected in the bill, incarcerated individuals maintaining and strengthening connections to their families and communities, which we know is vital to their success, reduces recidivism, and the overall public safety. The shared priority is clear through the department's budget requests in both 22 and 23. However, I want to take a moment to speak to a few implementation challenges we've encountered since the implementation of free phone calls last year. And I'll explain some of the costs of the DOC of the bill before you based upon current contract costs. I will note that the executive director of MSOP and their director of security, as well as representative from the Office of Procurement at the Department of Administration, are here with us today to answer any questions you may have for them. As you are aware, the DOC implemented free phone calls last July. This shift to open communication for members of the population has been overwhelmingly positive for both the incarcerated as well as their families. They can seek more individualized services, better plan their reentry, speak to their children and supportive members of their communities, and generally stay better connected to the outside world. That said, as a department, we've learned a lot upon the implementation, and certain challenges have become more clear. First, our cost has increased, and call volume we estimated was too low. The legislature had appropriated $3.1 million each year ongoing, based on call volume, about 7 million minutes per month. Costs are likely to exceed $3.6 million a year, and I want to emphasize this is under our current contract. Second, ensuring fair access to phone calls for all incarcerated individuals has been an ongoing challenge. While not representative of the majority of the incarcerated individuals in our population, we, like many other states, have had security threat groups use strong-arm tactics to control and commodify the use of phones, at times prohibiting more vulnerable incarcerated individuals from freely accessing the phones. In addition, states like California are faced with ADA lawsuits due to access issues related to expanded phone use. We have had fights break out in our living units and related phone use issues, and we've had to
apply staff to address these security concerns, pulling staff from various other areas. Third, we've had to apply staff resources to monitor criminal activities transpiring over the phones. This is not a new thing, but it is something that has notably increased. We have to monitor people attempting to contact victims and those with protective orders. This is another area that we are looking to address with a biennial budget request for additional staff next year. And we're aware that DHS is working on a fiscal note that seeks to address security monitoring issues based upon the experience of the DOC. And finally, fourth, under the current statutory language, once we negotiate a new contract, we will be unable to backfill a fund that covers some programming costs for religious activities, prison library, newspapers, subscriptions, and recreational equipment. The language in the bill before you disallows the collection of commission in existing contracts, which would create a budget shortfall for these services. Finally, I would just say that renegotiating a contract can be challenging. Renegotiating could change the scope of the contract we are currently in with the provider, which could result in challenges or litigation from the vendor community. The Department of Administration can attest to the fact that contracts in this space are some of the most complicated, lengthy, and litigious that the state negotiates, often taking 12 to 18 months to finalize. The DOC, MSOP, and the Department of Administration are working through options, and we can assure you that we want to have a communication system that benefits and supports the rehabilitation of the incarcerated population, provides for the necessary security provisions, and demonstrates effective stewardship of state resources. We are aware that there are entirely new models of communication systems in the correctional setting, offering considerably less expensive per minute wireless based models, and we are very interested in exploring these models. Implementation of these models may require the DOC to invest in wireless network systems. We have initiated preliminary steps to develop a request for proposals for these and other services. We do not know the cost, what this will be at this point in time, but we do know that the request for proposal will result in lowered costs as the marketplace has changed considerably over the past 5 years. I would just say that implementation of free phone calls has been a complex but very worthwhile endeavor. We're committed to the shared priority of opening lines of communication between the incarcerated population and their families. In that work, and as the legislature decides on any further expansion, we only ask that the cost of expansion be funded to avoid a budget deficit for the department. And it is difficult for us to know what the cost will be until a new contract is awarded, and we know the model that best serves the needs of our population. And with that, I would stand for any questions that you or the committee may have.
Thank you, Commissioner. While you're there, any questions from the committee for the Commissioner? All right, thank you. And Sheriff Jim Stewart, I understand, is also present. Members, I'll call your attention to a letter that's also being distributed from the Minnesota Sheriff's Association. Mr. Stewart.
Thank you, Mr. Chair, committee members. I think I could save everyone. Well, for the record, my name is James Stewart. I'm the Executive Director for the Minnesota Sheriff's Association and representing the 87 elected sheriffs across the state, and I think I can save everyone my testimonial time by a point of clarification that this would only impact the state prison facilities and not the local jail facilities. There was some striking of the state language, and just knowing that that was the case, it certainly created some concern across the state. And the trifold areas, just to be very concise, is one, of course, the loss of revenue to the counties, but more specifically that those revenue streams are used to support a lot of other inmate programs. And should that funding go away, then a lot of things such as the fitness centers, such as TVs, mattresses, a lot of the daily operations, things that are designed to support the local inmates
would be dramatically impacted. So again, rather than going into my prepared presentation, if I could clarify that it only impacts these state facilities, then I will stand down.
Senator Oumou Verbeten.
Thank you, Mr. Chair. Yes, this bill is just state facilities only.
Awesome. Thank you very much. Thank you.
Thank you. Mr. Stewart, for what it's worth, since you brought that up, in my judgment, the inmates should not be paying for their own mattresses and televisions. And if it were me just waving a magic wand right now, I'd give them all free access to telephones in all facilities in Minnesota of incarceration and make the counties pay for the actual costs of incarcerating the offenders that they decide to send to jail.
Understood,
So
Mr.
send
Chair.
that back to your membership if you wish.
Understood, Mr. Chair. Just the sheriffs certainly have that reality that the money has to come from somewhere, and they've got to go back and negotiate with their county boards for that funding, which, as you can imagine, is oftentimes an uphill battle. And so with all 100% of those funds currently being reallocated again for fitness centers and even tablets and rehabilitation training and libraries and things like that within the facilities, we just know the reality that should that funding not be there, many of those services that we want to be there for our incarcerated community members would likely not be there as well. So we want to be a good partner at the table, so thank you.
No, I appreciate the information. I'd be happy to provide you with some leverage in those negotiations with the county boards if it comes to that.
Roger that. Thank you, sir.
Thank you, Mr. Stewart. Anyone else in the room wish to testify in connection with the bill right now? I understand there's been a fiscal note requested. Is that correct, Mr. Turner?
Yes, Mr. Chairman. The LBO hasn't signed off on it yet. I think Human Services is still working on their part too, but the Department of Corrections has completed their section of the fiscal note.
Okay. And we're anticipating the path for this, if it passes out of committee today, to go to Human Services and then return to us because any fiscal impact would be within our budget. Is that correct, Mr. Turner?
Mr. Chairman, it either come to us or would go to finance as an independent bill.
I see. Okay. Thank you. So I'm not seeing any other testimony. Let's open it up for committee discussion or questions. Senator Carlson.
Thank you, Mr. Chair. I guess I have a question that perhaps one of the law enforcement officers or Commissioner Schnell should answer, and that is, what does it cost to run a phone system in a facility like that? Because I'm under the understanding that there's recordings that have to be dealt with. There's other kinds of monitoring of maybe times of the person and, of course, the billing. Is that something that you contract with an outside company? And I guess, what I've thought of is that, we're using this to some degree as a fundraiser for other things in the facilities there. But I know that it's not going to be the same as my cell phone and sitting here and calling anybody. But there must be some kind of cost that's a basic level to make sure that this a phone system like that can be run.
Commissioner Schnell.
Mr. Chair, Senator Carlson, I'll just describe the way this works in our system today. We have a vendor, as Senator Oumou Verbeten kind of described, that provides a system, a network. They make phone calls. They record all of those phone calls. They can set limitations on those phone calls for how long they can make them, what numbers can be called. So there is, considerable ability to limit calls. All of that is stored and recorded, obviously. Right now, we bear that cost at that billed rate at right now about 4 cents per minute. We retain a penny of that. A minute comes back to us in commission, so 25% of that is, commissioned or effectively is returned to us. So that's how this system works. And what the new models are beginning to look like is much lower cost with IP-based systems and just considerably new technology, which really makes the cost
much lower, much easier to manage. And that's really what's changed over the past 5 years, which makes the systems much less costly.
Senator Carlson.
Just one follow-up. Are the phone calls limited in time and limited in the number that a person can make those calls? We all know that some people love to talk, and they might keep a phone call going for some time. Is that something that the vendor also makes sure that they keep track of and or limit or shut it off at a particular time?
Commissioner Schnell.
Mr. Chair, Senator Carlson, the Department of Corrections sets that limitation. We have no limitation on the number of calls a person can make, but we do set the limit of 15 minutes. And we do that for the purpose of making sure that people can access the phones so that, there's a lot of demand to get on the phones and for people to get on. So that 15 minutes just allows for more people to access the phones.
Thank you, Mr. Chair.
Any other discussion? Senator Kroon.
Thank you, Mr. Chair. This question might be for the commissioner. I'm not sure, but just to make sure I'm understanding how these phone calls work, you have existing contracts with providers right now that you think are on the expensive side of what they could be, but you have a long-term contract. So right now after the bill last year, the Department of Corrections is paying for those calls at that higher rate under the existing contract. Is that right?
Commissioner Schnell.
Mr. Chair, Senator Kroon, yes, we pay at that existing rate. Where that contract is coming up it will end here, end of June. We will be going out to bid for a new contract.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. So last year was 3.6 million. You're anticipating additional costs because we're expanding, or this bill would seek to expand it to human services facilities. Sounds like there's some enforcement issues with fights and that sort of things, and then you have the contract with the provider. So it sounds like the cost is going to go up, but then potentially could go down as the contract with the existing provider expires. But on the other hand, it sounds like you may need to invest in some infrastructure to get those cheaper rates as well. So there would be some costs associated with that. Is that a good summary?
Commissioner Schnell.
Mr. Chair, Senator Kroon, I think it will depend upon the model. And this is the process of the RFP. It may be infrastructure. It may be just a cost reduction. So one of the things that, as I said during our testimony, we know that the cost will be lower. How much lower, and what that model is? It going to be that we have to establish a network, a secure network that this communication system will operate under, or will a vendor provide that for us? Those are things that we will have to establish through the RFP process, but we don't know what that is. In our fiscal note is based upon the contract as we know it today, because that's what the LBO requires us to submit, the cost as we know them today.
Mr. Chair.
Senator Oumou Verbeten.
Thank you, and Senator Kroon. I just want to echo what Commissioner Schnell is saying and make sure folks understand, how I would kind of think about the different models is there are vendors who will provide the network, provide the tablets, the actual hardware. They'll typically have more of a higher ongoing cost. And then there are vendors that will incentivize the department to invest in some of that infrastructure themselves, and that can significantly bring down the ongoing costs. I'm not saying that one of those models is best. It's going to depend on the information that they get in the RFPs, but I think we are all pretty confident that there are better rates available. We can see that just in what other states are paying and the models that other states have chosen to implement these policies. So I think the department is doing a good job in both their RFI and RFP process right now of trying to get a sense of all those different models that exist, the different ways
the different sort of cost models as well. If it's per tablet, if it's per person, if it's by minute, if it's by month, there's a lot of different ways to approach this. And also our testifier, Andrew Lama, and the folks at Worth Rises are really experienced in this, have a lot of data and research on the different ways that you can approach those contracts with vendors.
So members, I'm just cognizant of the time and the fact that we do have 2 more bills to hear, and this bill is going to come back to us if it leaves committee here today. But I do have a question. The proposal for today is to expand beyond phones to video. Is there anything unique to that expansion that we ought to keep in mind as we decide on this bill today?
Well, I will just start. I'm sure the commissioner has more things to say, Mr. Chair, but I do think there's a huge opportunity when you're looking at all of those services. So getting a new vendor and giving them the business for phone, video, electronic messaging, and showing that you can provide a sort of volume for those services, they can offer better rates. So I do think it's important to think about the sort of bundling that can happen here when we're looking at a new vendor that could potentially provide all of these services and do so at a lower cost.
Okay. I would assume it would also expand the monitoring resources that are necessary. Mr. Commissioner Schnell, you're nodding your head vigorously, yes.
Mr. Chair, yes. And there are now ways to do some of this, even using technology.
All right. Thank you. Senator Limmer, I want to turn to you because you also had a question or comment.
Thank you, Mr. Chair. Commissioner, while you're at the desk, I know that telephone use by inmates can certainly relax the mood in a facility. Does the Department of Corrections, do they occasionally deny a phone privilege for a disciplinary purpose?
Commissioner.
Mr. Chair, Senator Limmer, yes, there are people who, when there's abuse of the phone or engage in activities that are prohibited through the use of the phone, yes, phone privileges are cut off.
Yeah, and Mr. Chair, Commissioner, this bill, the way it's written, if it becomes law, does that negate any possibility of you changing the policy at the Department of Corrections for that purpose?
Commissioner.
Mr. Chair, Senator Limmer, I don't believe so. I think the policies around the operation of the facility for the safety and security of the facility, I don't believe would change by virtue of this bill.
Any further questions or comments from members of the committee? Senator Oumou Verbeten moves that Senate File 4387 as amended be recommended to pass and be re-referred to the Senate Committee on Human Services. All those in favor say aye.
Aye.
Opposed? Motion prevails. Senator Oumou Verbeten, your next bill, Senate File 4737, Safe at Home Provisions. And if there's staff from the Secretary of State's office, come on, wish to testify, come on forward. Members, the file is being distributed to you.
Yeah, that's perfect.
This is the first committee to hear this bill. Not aware of any amendments.
Thank
Senator
you.
Oumou Verbeten.
Thank you, Mr. Chair. Safe at Home is our state's address confidentiality program for people with very high safety needs. When people enroll, the office assigns them a St. Paul P.O. Box address that all public and private entities must accept and use as the person's real address. And then only the Safe at Home office knows a participant's true address. It assists participants with forwarding their mail, helping them with interactions with third parties, problems with party stakeholders, and just helping participants understand how to use their Safe at Home address. That's all things that the office does. So the changes here would improve the program's effectiveness in 2 main ways. The policy change allows an individual to apply to the program if they are not a resident of Minnesota but intend to move to Minnesota, and to allow individuals or entities to mail to an alternative designated mailing address under limited circumstances. And those clarifying changes are not intended to make any substantive changes, but just to clarify language as some questions have come up from stakeholders. And Nicole Freeman is here from Secretary of State's office to help answer any questions.
All right. Anyone else in the room wanted to? Ms. Freeman, did you want to say anything affirmatively or just answer questions if they come up?
Senator, I could briefly go through a high-level description of each of the sections, if that's helpful.
Sure, go ahead.
Okay, thank you so much. Nicole Freeman, Office of the Secretary of State. As the Senator mentioned, the program serves over 5,000 participants, served over 5,000 participants last year. And the bill, as she also mentioned, makes 2 policy changes and 2 technical changes. These changes are brought to us both by partners as well as staff through the at the Safe at Home Division. So sections 1, 2, and 3 allow an individual to apply and become a participant if they intend to move to Minnesota within the next 60 days. Section 4 allows a person or entity to send mail to an alternative mailing address rather than the Safe at Home PO box in very limited circumstances. And then sections 4 and 5 make the clarifying changes to address questions from stakeholders. I'm happy to answer any questions that folks have. Thanks.
All right, thank you. Anyone else in the room wish to testify in connection with the bill? Any questions or comments from members of the committee? Members, my understanding is it was intended that we lay this bill over, but Senator Oumou Verbeten, there's also an option of sending it to the Senate floor. Would you prefer to have it laid over?
Mr. Chair, we could just lay it over.
It's more likely to be heard if it ends up being laid over at this rate than if it's sent to the Senate floor. So, all right, members, Senate File 4737 is laid over. And Senator Westland, Senate File 4385, being passed out. Members, the anticipation is that this bill will be laid over for possible inclusion in our budget bill. Senator Westland, to the bill.
Thank you, Mr. Chair and members. My goodness, I thought we'd never hear this bill. It keeps getting bumped. So thank you so much for the opportunity to present this bill. This is actually a follow-up from our work last year. We heard a bill last year, Senate File 691, that dealt with hate crimes and crimes motivated by bias. That bill was actually included in our omnibus bill last year, and it included this funding provision, as I understand it. However, the funding provision for this piece was removed in conference committee. And so my partner in the other body brought this again this year and asked me to be our Senate author to try and reinstate that funding provision. Senate File 4385 is supported by a broad coalition of groups. There is an organization called Communities Combating Hate. It's a coalition. It includes the Anti-Defamation League, Jewish Community Relations Council, Council of American Islamic Relations, Coalition of Asian American Leaders, and more than a dozen others. And all of this coalition has provided support for this bill as well as for Senate File 691 from last year. This proposal emulates a model policy that is currently being piloted in Hennepin County, and it would be an opportunity for communities in greater Minnesota to be able to bring this community education work to their communities. There's evidence from studies from American University and others that have shown that it is easier to prevent radicalization and violent extremism by investing in public health models that emphasize people's needs. And this bill essentially, again, would provide grants to community-based organizations in order to promote intergroup harmony, deepen community resilience, across lines of difference. And this is work that is already being done by community groups here in our state. I believe I have folks here who can answer questions, if any, but again, the purpose would be to lay this bill over. And again, this would be taking a project that already exists, a pilot project in Hennepin County, and providing funding for other groups and organizations to participate in these sorts of community initiatives.
Senator Westland, are there any proposed restrictions or guidelines for which organizations will be eligible for this grant funding?
My understanding, and I would look to staff in case, but my understanding is that DPS would actually hold the funds. They would determine the application criteria. The activities would be proposed by the organization seeking the grant, and it could include things like public education, training initiatives, and so forth. So my understanding is that DPS would actually look at requests for grants, and based upon those requests would determine whether or not an organization would receive funding.
I, for one, would be a lot more comfortable if there were some more articulated criteria set forth in the legislative guidance, rather than just saying, here's $1 million, DPS, you decide what the criteria are for sending this money out the door.
Mr. Chair, do you have suggestions? I'd love to work with you on that if you have some.
I'd be happy to work with you on that, Senator Westland.
Okay.
Any other questions? Senator Limmer.
Thank you, Mr. Chair. Mr. Chair, I have similar concerns as you do, especially on the words intergroup harmony and community resilience. I don't know how you measure those terms. And in addition to that, the author said that this is already being done by other groups in our state. So why don't we just give more money to the existing groups rather than create another one? So maybe you could expand on that and how we would measure intergroup harmony and community resilience.
Senator Westland.
Mr. Chair and Senator Limmer, again, I guess I would refer you to a coalition, a broad-based coalition, Communities Combating Hate, and those are the sorts of organizations that would probably, they're probably doing some of this work already, that probably need some funding to continue to do the work. It's a wide-ranging group that includes, again, a variety of organizations representing different backgrounds. I think that we know that hate crimes and bias crimes have actually been on the rise. We know that current geopolitical circumstances have created a rise in both anti-Semitism and Islamophobia. I think we have seen interfaith organizations that have typically worked well together and had good relationships with one another, probably experienced some strain and stress. And I think that those are the types of organizations that typically work across lines of difference to try to combat sort of this extremism and radicalization that results in hate crimes, bias crimes, and violence. So again, this was part of a bill brought last year that was part of a larger package dealing with hate crimes and bias crimes, with the intention that oftentimes community organizations on the ground are in perhaps the best position to often know where to interject, where to intervene in order to try to reduce and combat those types of issues.
Senator Westland, off the top of my head, one of the restrictions I would be interested in is that the grantees not themselves have acted inconsistently with the values that are being set forth or the goals of this legislation or grant funding.
Can you repeat that, Senator?
I would be opposed to funding any organizations that have themselves not acted consistently with the goals of this legislation. So
I would, and Mr. Chair, I guess I would assume that in the DPS process of someone's asking for funds for the purpose of intervening and reducing bias crimes, that they probably aren't going to invest in groups that have engaged in bias and hate. But again, Mr. Chair, if you have, I would be happy to work with you on any specific language that you might have. I think that the language needs to be broad enough that it's manageable, and that DPS needs to have, clarity about what our intent is. I think both of those things need to be true.
Any other conversation or discussion in connection with this proposal? Members, this is $1 million being requested. It would come out of this committee's budget target, so we are simply going to lay this one over for possible inclusion.
It is scalable.
Senate File 4385 is laid over.
Thank you, Mr. Chair.
Next meeting. Members, we are hoping to have our next meeting on Monday. It depends how long the floor session takes, whether there'll be any time left for this committee to meet. We are not able to meet Wednesday because it is a Senate holiday. So we will plan to meet Friday, April 12th. Time to be determined. Basically, much of what we aren't able to get to between now and then will be on the agenda for the 12th. So plan accordingly. And Senator Limmer.
Thank you, Mr. Chair. It's been noticeable that we are making decisions on policies beyond the policy deadline. And that definitely is something new for our committee, regardless of who controls the majority. Occasionally, even under different hands, there would be an occasional bill that would be late. We seem to be getting into quite a number of bills above and beyond. Could you explain why we're going down this path, and how long do you anticipate having our committee make policy decisions beyond the deadline as established by Senate rules?
Well, Senator Limmer, that's a fair question. This committee unfortunately lost 2 hearing days in connection with the deaths of our law enforcement officers and the EMT in the South Metro, just because one of them was the day after the incident, and the other committee hearing was, the funeral was scheduled at the same time. We also lost at least one committee hearing because the floor session went long. So we also received an unexpectedly large number of re-referrals from other committees that had judiciary, public safety pieces of larger bills that absorbed more of our committee time than anticipated. So yes, our expectation is that there will be some late bills. Our policy bill is going to be late, and I mean, the leadership is aware of that, and they understand the unique situation this committee is in with regard to re-referrals and the time lost to our regularly scheduled committees prior to the policy deadline. We've also found, so we're going to have probably, we'll have one omnibus policy bill. We still have the budget coming up, and we're still within the deadline for that. I'm anticipating a sort of a mini compact omnibus bill. I think there were maybe 6 compact proposals that came to us, or is it 9, something like that. And the main hitching point for all of them was the part within our jurisdiction dealing with venue and liability. So that is still being worked out, and that will be a late bill. And my anticipation of the Rules Committee would look favorably upon our circumstances and move bills on accordingly. Some of the policy bills, or some of the bills that we're hearing also, as you can tell, we've heard them so that they can be included in other omnibus bills from other committees, even if it's not formally being sent back to them. more important for us to get our work done and have our input at this point. Any other questions or comments? All right, members, thank you for your work today. We're adjourned.